the first question, and to the proponents, would you take a moment to assess the strengths and weaknesses of the negative team's response to the question?
Yeah, I think I think one of the biggest strengths that they have is definitely their resources and their citations of, I didn't really catch the specific names, but Twitter kind of things. I think that's very useful in this debate, just because, you know, it's kind of social media is kind of like a newer invention, really. and so obviously, you know, when we're talking about censorship in social media, that's obviously going to be a different, a very newer discussion. It's going to be harder to find those resources. So I applaud them for that. I think one of the weaknesses, I didn't hear, this could just be me, but I didn't hear the top 3 contentions, and I didn't hear them mention exactly how government censorship would be inherently dangerous. I just heard that it was dangerous.
Negative team, would you like to expand on why it's dangerous for government to engage in the censorship?
Yeah, I would love to. So really, I think this debate boils down to, you know, one key concern. And the affirmative articulated the first concern, which is the free speech rights of individual users of social media. But that must be weighed against the private rights of these companies and the individuals who run these companies not to speak. And so, for example, Twitter can't use another platform to speak. Twitter can't create Twitter 2.0. So by allowing government regulators to come in and politicize what social media's companies can and can't do, you're violating their right to not speak, as well as their right to pursue their private business interests. The First Amendment is specifically protecting all of us against the undue insertion of government power in what we can say and what we can do. However, in these private platforms, in these private business interests, the First Amendment specifically protects companies' ability to do that same thing. And if we were to affirm today's resolution, what we're doing is bringing a political struggle and socio-political influences to how we engage in discussion online. We believe that's harmful because it politicizes tech and gives politicians the ability to regulate who they want and what social medias they want, while ignoring other instances of abuse online.
Proponents, would you like to address that question of individual free speech versus the company's free speech, the free speech of the social media company?
Yes, thank you. So it kind of gets into a little bit of a gray area, because it's true that social media companies have the First Amendment rights, but so do individual users. And because social media companies are not government entities, they don't have to protect the First Amendment rights of their users, whereas the government itself, by definition, with the First Amendment right, has the imperative to protect and uphold free speech. And as we've seen, as the affirmative showed in our opening, regulation is not unwarranted and it's not new. You know, social media is a new phenomenon, and so it's really only a matter of time before there is government regulation in place to further protect the free speech of the users on these platforms. And as I said before, the CEO of Facebook has stated himself to be in support of legislation to regulate social media.
Thank you. Negative team, the proponents make an argument that social media platforms are a new phenomenon. You point out that the courts are beginning to address this question of free speech on social media platforms, but that the size and the use of these social media platforms is really bringing them into becoming a public square type phenomenon where the individual speech is more important than the company's speech. Could you address those points?
Yeah. I think one case that actually really explains this really well is Manhattan Community Access Corporation versus Halleck. And this court case was heard in 2019, and it was basically addressing the question of whether equal access to social media and public cable TV networks constituted the same thing as a public forum as it is considered by the government. This case held that it was not in a 5-4 majority. A number of the Twitter cases that we've brought before you in our original case all ruled the same thing, that Twitter, Facebook, and these social media companies, because they are private platforms, because they have their own right to free speech and their right to pursue their economic interests, do not qualify as what's considered a public forum under law. And therefore, since they are not public forums under law and they are private entities completely, they can choose how to regulate, moderate, and approach content moderation on their own platform.
Proponent side, do you want to respond to that?
Yes, thank you. So it's true that the Manhattan example, I apologize, I don't remember the full reference there, did show that because social media companies are not a government entity, they don't have the same liability to enforce free speech. However, social media companies are publicly traded companies. Every social media company except for Instagram, which is owned by Facebook, who is still publicly traded, are publicly traded companies. So they still have a certain liability to their stockholders. However, the current legislation that I referenced before, Section 230, it actually takes the liability off of social media companies from monitoring their websites. So it leaves it completely freely up to them. And as we have seen, with given the freedom to decide how they regulate or do not, most of the time they do not. As I said before, Twitter itself does not have a misleading information policy. And so, additional legislation is not unwarranted. It's pretty standard in this situation.
Thank you. The opponents argue that the marketplace is a sufficient governor to protect free speech rights on social media platforms. Please address that question, that point.
Yes, the question was to myself?
Yes, or your teammate.
Okay, thank you. This is problematic, allowing the open market to regulate itself, as we can see with users kind of bandwagging and reporting social media pages or content that they don't agree with, and resulting in either permanent or temporary bans of those individuals. It is not a regulation in place by these social media websites regarding their code of conduct or other misinformation policies, but rather it is on the whims of individual users, what they do or do not agree with, or what they find controversial. And as such, it is not an effective way to enforce information regulation, simply because it is biased and not consistent.
Thank you. Negative team, you've cited several court cases that are upholding the rights of social media companies for their free speech. But let's take the broader question of whether, as social media platforms become more and more the platform where people express their speech, does government have a responsibility to protect how does government balance the right of free speech of individuals, knowing that social media is one of the key areas to express that free speech versus the company's rights to free speech?
Right. I think that's a great question. And this kind of alludes to what the affirmative team has been saying, in that there have been regulations in the past. But we think there's a huge difference between the regulations that have occurred and then the regulations that the affirmative is arguing for. The affirmative is uniquely arguing to disallow social media companies from banning users, which we have shown is a violation of their right not to speak, the reciprocal right of their freedom to speech. So we think that there are different regulations, and some regulations, yes, are good. We do think that social media companies should collaborate with the government and have those discussions of what a responsible social media company is and what that entails. But we don't think that should entail regulations that violate their freedom to not to speak.
And if I could just add on to that, the other thing here is that individual social media users, first off, are often only temporarily banned, which means they can easily regain access to these platforms. Second, they have the ability to go to other social media platforms, to go to other public forums, and continue to use their right to speak freely, to express themselves freely. The difference here is that these companies don't have the same option. Twitter doesn't get to make Twitter 2.0 in order to actually have their right not to speak. And we believe that it is not a good precedent to set to violate one group or one entity's rights in order to protect the others, especially in the situation where the rights under the First Amendment are specifically protecting individuals from government censorship. Private censorship has been upheld and is one of the rights that private companies and private forums get to use and get to employ. And therefore, we believe it is far more harmful to be violating the right not to speak of these social media companies than forcing individuals to have to go to other platforms or other public forums in order to use their speech.
Opponent team, you mentioned that there may be certain types of regulations that social media companies should enter into with government. Could you discuss what types you think would be allowed?
Yeah, so there's already some examples under Section 230 where the social media companies, for example, are supposed to regulate child pornography, which I think we can all agree is something that shouldn't be on social media sites. They're supposed to regulate instances where people are violently threatening other people, right? So there are instances where social media companies and governments have a responsibility to collaborate to protect individuals' right to life and their right, to be safe in these environments. However, I don't think that that's the same thing as completely taking away social media companies' right not to speak.
Thank you. Proponents, do you have any thoughts or responses to that?
Yeah, I'd like to respond. So what our opponents are talking about is taking away the right to free speech, in a sense, to those companies that host those platforms, which in our opinion, we think that, government legislation, first of all, to stop those companies from banning individuals based solely on political viewpoints, we think it would actually protect both the companies and the individuals, mostly just because, they'd be answering to, our complete legal system and all of our laws and, legislations, our bills, all of that, our government that's run by and for the people. But private companies, they have their own, wills, they have their own biases, they have their own agendas. So I think, in a sense, it'd be much safer if we let the government decide, essentially, just in this one instance, who can be banned and who cannot be banned. Because it's such a platform and it's such a big part of free speech in the world today.
May I add to that?
Sure.
Okay, sorry. I thought that was a head nod, but I couldn't tell because you're very tiny.
Fair enough.
Yes, so as we showed in our opening, there is legislation already in place to regulate other media platforms that protects the free speech and the rights on those platforms. But in addition to that, Section 230 also does this for social media. So David Green, who is a senior attorney and the Civil Liberties Director at the Electronic Frontier Foundation, stated that without Section 230, social media companies would have to pre-screen all content and micromanage their users. So not only does it protect their users from micromanaging their free speech, it protects the social media companies from liability of that speech. And in addition to that, the congressional hearings have just caused an overall distrust in social media companies. And, it's not unwarranted, especially in the face of the election interference from 2016, that social media companies might have further overreach in their power to affect political matters, such as banning political users. The congressional hearings and the distrust, it's problematic because, as I said before, half of the global population uses social media, and our opposition suggests that if users don't like it, they can go to an alternate platform. However, platforms such as Parler are complete echo chambers. social media as it is has problems with that, but by going to alternate platforms that promote very specific ideologies, you're just causing users out of their distrust for the current social media platform to go to another that then further isolates their ideology and their exposure to civil discourse. So having legislation, increased legislation, or even reform of 230 has been in discussion for the past 2 years and was only put on hold because of the pandemic, it would increase this trust by putting those protections in place and decrease the divide and the echo chambers of our democracy.
Thank you. Opponents, would you like to respond to that?
Yeah, so there's a lot there. So I'll try my best to capture some of those major points. The first thing I want to note is that on the question of echo chambers, in the affirmative world in which there are no bans, or that the government is the one banning those individuals on social media companies, echo chambers will continue to exist. We showed that government has its own biases, wills, and agenda, just like a social media company would have. Transferring that right from the companies to the government doesn't really change much, and it's a matter of silencing the rights of free speech for those companies, for the trade-off of just moving that attention and that power to someone else. I think that's a key point to make sure. Just look at what the affirmative world will look like, and that they still have those same problems that the affirmative is talking about, and only the negative can help achieve and resolve some of those issues that they're bringing up.
I also think, to add on to that, on this echo chambers argument, even if we got rid of all bans on social media are set up that you get to choose who to follow, you get to choose who to listen to, you get to choose who to retweet. And when you look at maps of like social media networks, people generally still self-select into groups of their own identity and their own political affiliation. So whether or not you get rid of these bans, even in like everyday conversation, right, we generally tend to associate with people, you know, we like and we agree with. And I think that that's a problem in especially an increasingly polarized world. But it's not like the reason echo chambers exist in American society is because social media companies sometimes ban users. Echo chambers exist in broader American society overall. And so I just don't see how the affirmative world gets rid of these echo chambers on social media, forces people to follow and listen to new voices and new perspectives, because it doesn't.
I'd like to respond if I can.
Please.
Yeah, of course, echo chambers are going to exist everywhere regardless, but you know, personally, I think I would feel better if you know, these social media companies had to basically kind of answer to government legislation, which, you know, is run by a democratic process and, you know, has laws and you know, legislation that is for the people's protection, for their First Amendment rights to free speech.
May I also respond, or was there another question that was going to be?
Respond.
Okay. It's true that the government does have bias. Bias is everywhere, of course. Humans are flawed. That's unavoidable. It's very rare to find a person with absolutely no bias. However, because the government has the imperative to uphold the First Amendment rights, they have guidance on their end to help eliminate that bias. And as my partner said, the democratic process tries to eliminate that the best it can. Whereas social media websites do not have a legal imperative. As it has been stated, they don't have to uphold the First Amendment rights of their users. It's true that in our world, echo chambers still exist. However, the negation hasn't offered really a solution to that other than individuals going to alternate websites like Parler, which only makes the problem of echo chambers worse. The AF, at least, has suggested actions to address these issues and potentially anticipate these issues and how they might present down the line.
Thank you. Jake, you've turned orange. Is that on purpose, or?
Yeah, they told us that's how we can request to ask a question. I don't know if that's.
Oh.
Yeah. So something awesome. Something you said in your last response was that these private corporations, you said, can restrict speech because they're not under the protections of the First Amendment, because the First Amendment is specifically about government censorship. But then you also say these social media companies are violating people's First Amendment rights. And so I'm just wondering how you, you know, can bring both of those perspectives in. It's either like First Amendment protects you from private censorship as well, or the First Amendment rights is specifically about how the government's censoring you. So what's your kind of response to that? How do we integrate both of those perspectives?
Yes, thank you for the question. So the First Amendment rights protect free speech, and among other things that are maybe not as relevant to this current resolution. However, it's a fine line, and that's why legislation would be a good solution to both of these perspectives and both of these groups of people as the users and the social media companies. As I said before, Section 230 offers these protections for both user groups, and the legislation currently proposed in Congress would be a reform of this current section to update it for the current era of the internet needs. Because this section was established in 1996 when the internet was first starting. It has grown substantially since then. It is, as I said before, it's unprecedented, this era in this platform. And so I think both the government and social media companies are very much winging it. And that's why having consistent standards of regulation in place ultimately protects both the companies and the users and the free speech of both.
All right, thank you. If there are no other questions, I think I'll.
Can I ask one more? I don't want to go over time if it's a problem.
Oh, Mr. Dean, go ahead.
Yeah, so I guess I'm just wondering, like, we're not debating Section 230 in today's resolution, right? We're debating whether or not the government should ban companies from banning users. So I guess whether or not Section 230 might need an update, might need some reform, that's a different question than today's resolution, correct?
It's a different question, but Section 230 shows the precedent of having government legislation to regulate social media companies, and the interference of social media in our political elections also shows the precedent of why that they can't be trusted when it comes to political matters, and why legislation would ultimately protect people from that overreach of power on behalf of these companies.
All right, thank you. With that, we will conclude this section of the debate and move on to the next phase. We'll have closing statements. Each statement will be 5 minutes in length. I will give you a warning at 4 minutes, and we're going to start with the opposition, the negative team.
Okay, perfect.
You look really confused. Am I allowed to do that?
Oh, you might be allowed to do that. They just told us staff goes first, but it doesn't really matter. So,
do you guys have a preference? I didn't want to screw this up.
I don't care. He can go first if he wants to.
Okay, negative team, you go first.
Sure. Can everyone hear me all right?
Yes.
Perfect. My time starts now. Jake and I agree with the affirmative team that bans on political figures from social media can be objectionable or even harmful to discourse. However, the key difference between the affirmative team's argument and us is that the response in the a response to unreasonable banning. They opt to allow federal governments to become the censor, whereas we argue that the consumer can exercise their freedom to force companies to change without infringing upon their rights. In recent years, we can see promise in the efforts of companies to be more responsible in their management of their sites. These companies are better apt to deal with these issues than the government, as they are more technically sophisticated, as shown by our Cato evidence. And Jake and I hope that public pressures will continue to make these companies more and more responsible. The first key voter in today's round is the politicization of social media companies. Although we certainly understand the affirmative team's desire to bring the government into these issues of online speech controversies, we think that their sentiment is misplaced. Recall our evidence from the Cato Institute's 2019 policy analysis, which argues that granting the government power to suppress companies' free speech gravely threatens free speech and the independence of the private sector. The affirmative in their opening speech talks about how global and massive social media has become. Do we want the US government to be controlling those decisions for every single person who's being the user? That doesn't seem to make sense. The affirmative team tells you that social media platforms are politicized, but they concede our argument that by allowing the government officials to violate the free speech rights of companies results in comparatively worse politicization of tech, in which regulation would fluctuate and would give whichever political party who is in power the ability to engage in real censorship, and that is a true abuse of First Amendment rights. The second key voter is disallowing social media companies from banning users would violate their constitutionally protected rights of social media companies to exercise the right not to speak, which is especially true given that these companies' terms of service that users are made aware of prior to joining the site. The affirmative team is likely to say that individual users are not super aware of what they're agreeing to, but those are things that can be reformed in the absence of the government making a regulation to disallow bans. And you should focus in the last speech that making sure that their offense and the things they talk about are specific to the affirmative's resolution. Recall a reference to Charles Johnson v. Twitter, in which the court ruled that the constitutional right to free speech includes the right not to speak. And because Twitter's rules were clear, they have a unilateral authority to terminate a user's account as an exercise of the right to free speech. The overwhelming court precedent that we presented today has been unanswered and supports our claim that companies have the constitutional right to ban users as an exercise of their free speech. Sure, the First Amendment is specific to those who are government agencies and the government actors, but are not specific to private companies. This has been applied to conservatives and liberals alike, as seen in the Tulsi Gabbard v. Google, Taylor v. Twitter, Britton v. Twitter, and the Federal Agency of News v. Facebook. Now, what this debate has really come down to is whether you think the threat to user speech outweighs the violation of rights to private companies. We have forwarded two primary responses. First, the court precedent highlighted by Jake in the first speech indicates that contrary to the affirmative's claims, people's free speech rights are not violated when social media companies ban them. Second, even if that is the case, it does to some degree. Pardon me. We understand that the affirmative. Pardon me. There are plenty of other social media platforms for the individual to still have their voice heard. For example, many people upset with Twitter bans have moved to create their own social media platforms on Parler. The affirmative team says this creates echo chambers, but one, they have not provided an impact to echo chambers, and second, we have proven that this is non-unique and happens in both worlds. Next, this additionally shows that the ability of people's power to reform social media companies. You, the user, have plenty of power over these companies, and we acknowledge and agree with the affirmative that Twitter and Facebook have and will continue to make bad decisions as to who they banned, but in a free society, they are allowed to do so. The beauty of free speech is that you, the user, are allowed to tell Mark Zuckerberg off and then go and use another service. And social media bans are actually almost never permanent, and this is seen in the affirmative team's definition, which shows that it can be temporary or permanent. A majority of the bans instated by Twitter and Facebook are temporary bans that avoid threats of inciting speech. And there exist many different public forums and public parks and public spaces for people to share their views to go elsewhere, not necessarily in the context of a social media platform. On to the specific arguments. We think that they say that social media companies are not accountable, and we agree that social media companies ought to be accountable and more responsible, but the passing of legislation to disallow social medias from banning users is not the correct answer. Government censorship only increases the violations of the rights of speech for both companies and users. They also tell you that free speech should be regulated by the government and not social media, but we agree. Sorry, that's the time then.
Thank you very much. Proponents, are you ready?
Yes, sir.
You may begin.
All right. In the world of the negative, anyone who is seen as a person with enough power to incite change in the world, both negative and positive, nonviolent or violent, can be banned from social media platforms. They would have you believe that legislation is government overreach, but the ability for private companies hosting a community that should be encouraging free and open discussion is acceptable. Promises from companies don't protect users from abuse of rights or privacy infringements. I'd like to give you all a quick refresher on what exactly it is that we've argued today. First, social media companies have such power that they are equivalent to open forums and thus should be subject to special regulations regarding free speech. Second, that social media companies are not capable of appropriately removing users, and we should not trust them to address the issues on their own. And third, banning users from social media based on their political viewpoints destroys civil discourse and creates polarized echo chambers that are damaging to our democratic society. We cannot afford to allow such a large part of our daily lives to be dictated by private companies. We believe that private legislation is an infringement on our First Amendment rights to free speech. I mean, if you think about it, wouldn't you rather have our government, which is a democratic republic that was created by the people for the people, to make distinctions on what and what not can be allowed to be said on social media? Social media is the most influential way that we can reach other people in today's society. Sometimes it's the only way. And allowing private corporations to restrict certain kinds of speech on these largely public platforms is unconstitutional in a very real sense. It's borderline dangerous to let these companies make the rules. Referring back to my second point, social media companies are private companies that host community forums and are therefore not subject to any sort of requirements that would prevent them from banning users based on their political viewpoints. Social media is such a powerful tool, and it'd be wrong of us to allow companies with their own biases to monitor these forums as opposed to the government, which is, once again, run by and for the people. In summation, we strongly affirm the resolution that legislation should be passed to disallow social media companies from banning users based on their political viewpoints. In the world of the negative, private companies with their own biases and influences have power to ban users on their platform regardless of whether or not it infringes on our rights to free speech. However, in our world, the world of the affirmative, our speech is regulated and protected by our government, with legislation passed by our leaders appointed through the democratic process. I would rather live in a world where I get a fair say in what and who gets regulated, especially when it comes to free speech. Thank you.
Thank you very much. With that, that concludes the second round of the Regents Cup today. I would like to congratulate our four participants. You did an excellent job. You've represented yourself and your institutions and Arizona well. So thank you for participating today and for your arguments. And I wish you the best of luck for the rest of the day today. Judges, thank you for your time this morning. We certainly appreciate your interest and your support in putting this event together. And good luck in trying to wade through that and make sound judgments on how our students did. So thank you, everybody, and have a great rest of your day.
Thank you.
Yes, you as well.